So, what happens when a simple children's storybook finds its way to the Supreme Court? Today, we're diving deep into the case of Mahmoud versus Taylor, a decision that could totally reshape what kids learn in public schools all across the country.
Take a look at this. It's called Uncle Bobby's Wedding, and it's one of the books that sparked a massive national debate. Seems pretty harmless, right? So how in the world did a simple story about family wind up in the highest court in the land? Let's get into it. To really understand how this book became such a legal battleground, we have to rewind and go back to where it all began, a public school district in Montgomery County, Maryland.
So, here's the play by play. Montgomery County Schools decided to add a new set of storybooks to their curriculum, books that featured LGBTQ characters. At first, it wasn't a huge issue. Parents could just opt their kids out if they wanted to. But then, in March 2023, that all changed. The school board got rid of the opt-out policy. And that's what triggered a group of Christian and Muslim parents to file a lawsuit saying the mandatory lessons were a violation of their First Amendment right to guide their children's religious upbringing. This lawsuit basically set up a collision course between two fundamentally different ways of seeing the world. First, let's break down the parents' argument for religious freedom, because this really became the bedrock of the Supreme Court's majority opinion. At the very core of the majority's thinking is this powerful idea, which Justice Thomas highlighted from a case that's a century old. The key phrase here is that the government has no general power to standardize its children. From this viewpoint, the school board's mandatory policy was a huge overstep, the state trying to force one uniform worldview on everyone. Now, here's where it gets really interesting. Both sides in this whole debate actually lean on the very same landmark case from 1972, Wisconsin versus Yoder. In that case, the court sided with Amish parents who didn't want their kids in public school past the 8th grade. And this set an incredibly high bar. The ruling said the state needs an interest of the highest order to justify stepping on a parent's religious freedom. That one phrase is what this entire legal fight hangs on. So, how does the majority use Yoder here? Well, they look at history. As you can see, early American schools were pretty basic. Sex ed didn't really show up until the 70s, and these specific kinds of storybooks, they're brand new, all published within the last decade. The majority's point is this. This curriculum isn't some long-standing essential part of education. It's a pretty recent invention. And that really brings us to the majority's bottom line. Because they see this curriculum as so new and not really essential for teaching basic citizenship, they argue that the state's interest just doesn't meet that highest order standard. And if it doesn't, it can't outweigh the parents' fundamental First Amendment rights to guide their kids' faith. The majority also made the point that these books aren't neutral. They point to scenes like this one, and they claim the books present a very specific view on family and marriage as being the correct one, as worthy of acclaim. So in their eyes, this isn't just about exposing kids to different ideas. It's about endorsing a message that directly goes against what the parents believe. But that's only one side of the coin. The dissenting justices, with Justice Sotomayor leading the way, saw the school's mission and the law itself in a totally different light. So let's dig into their argument. This quote from the dissent really gets to the heart of their entire philosophy. They see public schools as the main place where kids from every possible background learn how to live together in a diverse society. For them, preparing students for that reality is an interest of the highest order. And this brings us right back to that key precedent, Yoder. It's honestly fascinating how the two sides can read the exact same case so differently. The majority sees Yoder as a shield for parents against any curriculum that undermines their faith. But the dissent says, whoa, not so fast. They argue Yoder was about compulsion. The state was threatening to throw Amish parents in jail. Here, they say, nobody's being forced to change their beliefs. They're just being exposed to different ones. From the dissent's point of view, the school board was simply doing its job. They argue these books were brought in to make sure the curriculum actually reflected the diversity of the community. Plus, they're just being used to teach standard reading skills, like character and plot. The goal, they say, isn't to change beliefs. It's to teach mutual respect. Looking at a page like this one, the dissent would argue that the themes here are totally universal. It's about family, adventure, kindness, love, things you find in pretty much all children's literature. They see these stories as completely mainstream, not as some kind of radical indoctrination. So we've got two completely opposite legal takes here. But what's really fascinating is the deeper conflict bubbling just beneath the surface. It's really a clash over the meaning of harm itself. And it's rooted in a value that, believe it or not, both sides say they share. So with all this back and forth, is there any common ground at all? Do these two opinions, which seem like they're from different planets, actually agree on anything? Amazingly, the answer is yes. In all their legal arguments, both the parents and the school board claim they want the exact same thing, an environment of respect and kindness for every student. So, if they agree on the goal, why the massive conflict? This table gets right to the absolute heart of the problem. The fight isn't about whether to have respect, it's about what respect actually means and what counts as harm. For the parents in the court's majority, respect means protecting a child's religious upbringing from messages that contradict it. The harm, to them, is the threat of undermining their faith. But for the school board and the dissent, respect means treating everyone in a diverse community with kindness and acknowledging they exist. And for them, the harm is the social stigma and isolation that would be created for LGBTQ families if opt-outs were allowed. So what does this all mean for the future of the classroom? This case is about so much more than a few books in Maryland. The stakes are incredibly high for public education all across America. At the end of the day, this whole debate is driven by two completely opposite fears. The majority is afraid of a future where the government can standardize kids and push parents out of the picture. The dissent, on the other hand, is terrified of a future of administrative chaos, where schools are paralyzed by constant opt-out requests and can't teach kids how to live in a diverse world. And this leaves us with the fundamental question, the one that's at the very core of this whole case. In a pluralistic, diverse America, who gets the final say on what our kids learn in public schools? Is it the parents, with their constitutional right to direct their child's religious upbringing? Or is it the state, with its mission to prepare all children for life in a multicultural democracy? The answer to that question will shape the American classroom for generations to come.